Welcome to Tampa Home Talk with your host, native Tampa real estate girl, Katrina Madewell, a full-time, passionate, out-of-the-box thinker, love for home ownership kind of realtor with over 21 years of combined mortgage and real estate experience. Tune in every week at this time for expert advice on everything you need to know about home ownership, finance, maintaining great credit, building wealth, and making your everyday life better, and how you can be financially successful today and tomorrow. Remember, love where you live or let Katrina fix it. Now, here's your host of Tampa Home Talk, Katrina Madewell.
Good afternoon. Thank you so much for joining us for today's show. We have a great show lined up for you this week, and it's a topic that we get pretty regularly in and around the field. And sometimes, people have asked us, and we're certainly not the expert, which is why we love to bring in the guests like we have today. People ask about probate, and they ask about planning, and they ask about trust and guardianship and all these things that, unless you're in the middle of it, you probably are not going to give it too much thought to, right? Because it's one of those things nobody ever wants to think about. So our expert in studio today is Linda Faingold. She's with Tampa Bay Elder Law.
Yes.
Welcome to the show, Linda.
Thank you so much for having me.
And we had a chance to catch up as usual before the show, and it was interesting. And one of the things you said, and we'll talk on that a little bit later in the show, was there's actually times when people don't want to avoid probate.
Right. There's plenty of times where we don't want to avoid probate for various reasons.
Which was interesting. So I guess probably the best place for us to start is, if someone were to ask you, what is probate? How do you answer that question? What's probate?
Right. Everybody wants to avoid it, but most people don't know what it is. Probate essentially is the court process of moving one's decedent's assets to their beneficiaries. So that means the court overlooks it, and the beneficiaries or the estate is liquidated and dispersed to the beneficiaries. People don't like it because it's expensive. I mean, the one that makes out really well in probate generally is the attorney. So if you're wanting to maximize your estate to your beneficiaries, most people want to avoid it. It's also time consuming. On average in this area, 6 to 12 months easily. And that could be longer depending on if there's real estate involved, because sometimes we just have to wait for houses to sell or other real estate. And so,
not connected with the right people. We got to hook you up with that.
Well, we'll have to change that. Yeah.
But it's certainly a part of the process, depending on the market you're in.
Exactly. No, yeah, for sure. Most people that, pass away have a house of some sort or some kind of property. So that, sometimes we're motivated to sell maybe below market value a little bit. The beneficiaries just want to move on and get rid of it. But other times, you don't want to do that. So it can take a long time, as you know.
And there's a lot of stuff that, goes into the process, which probably another great place to start when we talk about, what happens in probate, because there's a lot of moving parts. I would imagine just like a real estate transaction.
Exactly.
We could tell you 105 things.
Right. I mean, essentially we're petitioning the court. We're identifying the assets of the decedent. We're identifying the beneficiaries. We're liquidating the assets. We're paying all valid creditors, so we have to determine who are the valid creditors, and then we disperse the estate. So it sounds very easy, but again, it's a process. So it takes a long time sometimes.
And what's the longest one you've ever seen, just out of curiosity?
Well, here's the thing that really will drag it out: when beneficiaries start fighting each other or challenging. So,
which is like, I have to share this story, not to get off topic, but we've had a number of attorney clients over the years that have had real estate or mortgage transactions with us. And, I had this guy that was actually a divorce attorney, and he was getting a divorce. And he's like, I cannot make my soon-to-be ex-wife understand that that's how we make our money. Yeah, exactly. Like, don't fight with me. Let's just figure it out.
Exactly. Well, again, in cases when people are fighting, it's the attorneys that win, and nobody likes hearing that. So, but I actually have had them last 5 years, 6 years. But sometimes, that's not just us waiting. That's for various reasons. Usually it's because people are fighting or the personal representative is not moving on, doing what they're supposed to be doing. So we don't like to see that. There's also other factors, like if the death was part of like a wrongful death suit or things like that. So we have to wait for other lawsuits to settle up, and then we finish the probate process.
The crazy part is, and this is the thing that a lot of people probably don't think about. I know it's something that I really didn't think about, but a lot of people are going to come out of the woodwork.
Oh,
right?
yeah.
Like dear Aunt Sally and
oh, yeah.
cousin Susie.
Yes. there's not too many people that are entitled once they're over the age of 18. So even children are not directly entitled to it. So if somebody puts their wishes in a will or a trust, generally it's pretty fair to say that it's going to go to the beneficiaries that they've listed. However, when I had a case about 2 years ago, the gentleman was in his 90s and he had passed away, but he left all of his estate to charities, 5 different charities. And this is a good example of when probate is definitely a better option. He passed away, and when I did his estate planning, when I did his will, he was already over 90 years old. And so when we probated his estate, his niece, long-lost niece, because he didn't have any children and his wife had already predeceased him, long-lost niece came out of the woodwork from Illinois and decided that she should be entitled to that whole estate because she was challenging his mental capacity for him to be able to actually write a will. Thankfully, I put things into place while he was alive, getting assessments and things like that.
And that's part of the due diligence process as an attorney, right?
Absolutely.
Like you guys are kind of verifying the mental capacity.
Yeah, if anybody's questioning that, or after a certain age, usually 90 is my limit. If they're over 90, just inherently, I have them get a capacity letter from their caregiver, not caregivers, their doctors and things like that.
Which makes sense for you,
Yes.
from a liability standpoint as an attorney.
Absolutely, yeah.
And it's crazy because I had my great grandmother. She lived till she was 93, total Spitfire with it, no dementia, no nothing. But it would make sense.
There's plenty of people in their 90s. 90s are the new 60s because they are mentally sharp. And so, but you always want to protect, as an attorney, I always want to protect myself. I want to protect what their desires are. So after their passing, we want to make sure that their estate goes to where they intended for it to go.
So let's back up just a little bit and even simplify it a little bit more. So let's say, in that case that you mentioned, he had no heirs, his wife was long gone, no children or anything, just a niece outside of the area. She's the one that actually files for probate? The niece?
No, I filed probate because in that case I was the personal representative, but she came in and challenged it.
Okay.
And when there is, to make his will invalid, basically, if a will is found invalid, it will revert to the statutory distribution.
Which says the heirs get it?
Essentially, yes, but there's a very specific way that it would go. So surviving spouse first, minor children, and then other children. And then if there's none of those alive, then it goes up the bloodline to the parents. If the parents not alive, then to the siblings of the decedent. And then if they're not alive, then that's where it gets into the niece and nephews and things like that. So in his case, being 91, his parents were long gone, his wife was gone, and he had no siblings. And so that's where this one thought she was entitled to the estate.
And it's crazy because people really do. I mean, they come out of the woodwork. Families that never think that they're going to fight end up fighting.
Oh, yes. I always say grief turns to greed really quickly. Whenever there's money involved, it's just like people in a divorce case. I mean, their bad side or their dark side comes out. And it happens, unfortunately, more often than not.
And it's, when I know you and I talked about a pretty profound statement, and if you don't mind, share your story because, I always love to know why people do what they do, right? Like if somebody says, hey, Katrina, why do you sell real estate? I have a very specific answer why I sell real estate. So I know before the show, you and I talked and I said, Linda, probate and and estate planning and elder law is such a very specific thing.
And not a very sexy subject.
Yeah, right. It's like nobody wants to talk about moving either, right? Like death, taxes, divorce, moving, probate, they're all up there together.
Yeah.
So we have to take a real quick break and we're going to leave you guys on the hook. But when we come back, we're going to have our guest, Linda Faingold, actually talk about why she does what she does. It's an amazing story, and if you think it doesn't apply to you, you're wrong. So stick around and listen because it's going to be great, I promise. Back in a minute. Hey, Katrina Madewell here. Just wanted to make sure you know how to reach us on our off-air number. If you'd like to connect with myself or any of our guests, you can call us at 813-377 2775. Again, this is Katrina Madewell, host of Tampa Home Talk, and to connect with myself or any guests we have on air, just call or text at 813-377-2775. 813-377-2775.
You've heard this before. Interest rates are at all-time record lows. But if your interest rate is 4% or above, you owe it to yourself to call Silverton Mortgage Specialist. Silverton is a direct lender, and the best part about this is that the entire loan process is handled in-house. From application to close, we do it all in the same building, which means that our loans close fast and our clients know what's going on every step of the way. Our contact info is located on TampaHometalk.com under Radio Show. What makes Silverton different? Products. We offer VA, FHA, USDA, and conventional loans pricing. Best rates with the lowest closing cost. Process everything in-house. It's handled right here and not outsourced to anyone that no one can reach. This way we can avoid surprises. Our people are simply the best, and we know you'll agree. What will closing Silverton Mortgage Specialist mean to you? A smooth process, real home loan value, and personal attention from real professionals. Silverton Mortgage Specialists are here to serve you. Visit TampaHometalk.com under Radio Show for all of our contact details. NMLS 109600 is an equal housing lender and Florida and Georgia residential mortgage licensee.
Curious what your Tampa home is worth? Here's an easy way to find out what homes like yours are selling for in today's market. Text the word value to 813-377-2775 for a free report on Tampa house prices. We'll send you a free report with up-to-the-minute statistics based on all homes for sale sold in your neighborhood over the last 6 months in all price ranges. To get your free report on Tampa Bay house prices, just call or text the word value to 813-377-2775.
Aaron Davis here, owner of Hillsborough Title, serving all of Tampa Bay. Our service, strength, and knowledge make us different. From Polk County to the Gulf, Pasco to Manatee, Tampa Bay, we've got you covered. Visit us on the web at thebesttitle.com. That's thebesttitle.com.
This is Michael J. Mayer, #1 international best-selling author of 7L, the 7 levels of communication, with the subtitle of Go From Relationships to Referrals. And someone who knows how to go from relationships to referrals is your host for Tampa Home Talk, Katrina Madewell. Listen, tell your friends, spread the word. You need to listen to Tampa Home Talk every Thursday and Saturday at 5 p.m.
Welcome back. You're listening to Tampa Home Talk. We are live in studio today. I'm going to give out the call-out numbers, which I don't always do. If you have any questions for our attorney in studio today with regards to probate, planning, or any of the such, 727-441-3000. Again, our studio call-in line with regards to probate, planning, estate, guardianship, elder law, 727-441-3000. So before the break, I promised we'd come back to this, and we were talking about why you do what you do. And I think when people do stuff for the love of what they do, or there's a strong why behind why they do it, they really show up when they show up. And I get that sense about you. Yeah. So what's your story, Linda?
Well, unfortunately, about 15 years ago, I had a brother who's 33 years old and he passed away unexpectedly. And at that time, at 33, no one does estate planning. He had a 6-month-old daughter, and you don't think you're going to pass away. And unfortunately, it happened. And what we didn't have in place, or what he didn't have in place, was any sort of advance directive, any sort of power of attorney, anything like that.
And can you break those down just for the person understanding? Because, I like to break it down in the most simplest terms. But an advance directive means?
An advance directive is a document that essentially, it's a living will document, as well as designating your healthcare surrogate. So a living will states that if you're in a persistent vegetative state, have end-stage condition or terminal condition, and any other procedure will be life-extending and not life-improving, that you would want things withheld or withdrawn at that time. So shutting off the machines, the Terry Schiavo kind of document.
Everybody's familiar with that because that went on for I don't even know how long.
A long time. But in our case, we didn't have that. And so it came down to an issue between his wife and my parents. And nobody knows who was right or wrong, but nobody knew what he really wanted. And he was past the point where he could make that decision.
Which that's the bigger picture there, right?
Right.
What do we want individually as people while we're here?
Right. And when when we know what somebody wants, or they've actually put it in writing, then it's a lot easier and a lot more guilt-free, if you will, to just honor what their wishes are. And then nobody has to make that decision. Well, unfortunately, in my family, that had happened. And after he had passed, I really, you have this epiphany, like, what am I going to do? Like, and so being an attorney is a second career for me. I actually quit my job, applied to Stetson, and they let me in. I don't know how.
What did you do before?
I was doing customer service for a computer manufacturing company.
Okay.
So for a long time. And, shame on them. They let me in. I went through law school, but I knew exactly what I wanted to do because I didn't want any other family to have to go through this. So when you think elder law, everybody thinks it's like people in their 60s, 70s, 80s, 90 years old, but it's not. It's actually for everybody. Every single person over the age of 18 should have a durable power of attorney in place, should have an advance directive, and then they designate their healthcare surrogate. So if they can't or are unable to communicate what their wishes are, that somebody else can step in and speak for them.
So, like in your family's case, what exactly happened? Like,
well,
spouse wanted to stay.
Spouse
keep
wanted
them
to keep them
around.
alive forever, and my parents, said it's time to let him go. And the doctors were saying it was time to let him go.
And that's painful for everybody. Like, how do you make that decision?
And you can't ever recover from that. I mean, just relationships in that 72-hour period at the end of his life were just, you just can't recover from something like that. So
what happened to him, out of curiosity?
he got lung cancer.
Okay.
He was 33 years old, not a smoker, and he went in for bronchitis, and after a couple of rounds of antibiotics, it wasn't getting any better.
So he wasn't even a smoker and he had
No.
lung cancer?
He had lung cancer, yeah.
Wow.
They had said, not to get too personal, but the doctors had said that he was pretty athletic, really in shape his whole life, that it might have, he might have been born with this tumor. And
Right.
because his body just, compensated, or that we didn't see
He was healthy otherwise.
he was healthy, and we didn't see it until it was too late. So
I think that's really the bigger picture here, Linda, is the fact that, somebody like your brother that was 33, I mean, it's younger than me. It's younger than probably everybody around. And, you don't think it can happen to you.
Right.
And what happens if it's, and that's a fluke thing, right? You don't smoke
Right.
and you have lung cancer,
Right.
but you could just as easily get hit by a car.
Correct.
Right? You could, crash on an airplane. You could,
Right.
if you ride a motorcycle, you could very easily be injured on that.
Yeah, dying instantly is different. If you die instantly, there's no decision to be made.
Right.
But it's for the ones that linger on, maybe for weeks or months or days even, and making that ultimate decision. And unfortunately, it is a life and death decision. And I'm not sure that I want to put that on anybody personally.
Right.
I want to make my own decision, for my own dignity. Dying with dignity is what they term that. I want them to honor what I want. And so that's my job as an attorney, is to put those wishes on paper, to find out what they are and put them on paper. And then there's no question. It makes it a
Just
lot
curious,
easier.
in that scenario, what do you see more often? Like, do you see the parents trying to keep their children alive and the spouse fighting, or you see that the other way around?
Don't know.
It's mixed
It is. It depends on the relationship. It depends on a lot of things. But, and like I said, neither one of them are right or wrong. I mean, it's what they thought he would have wanted.
And the crazy part is, too, like you and I talked about this, right? And my husband and I have both said, if this happens, that's not us. We're not going to do this. But if we don't have it in writing, I could just as easily be fighting his parents
Right.
about this scenario if he's in that vegetative state.
Exactly.
And that's the whole point of today's show.
That's exactly right. Yeah.
So I know before the show we had talked about, many times people want to avoid probate, and we'll talk about some times that you see where they don't want to avoid probate. But what are 10 ways that someone can avoid probate?
Okay. I only came up with 8.
Okay.
It's not even avoiding probate. There's ways to
We're going to save the
bypass.
last 2 for reasons why you don't. Right?
Okay. Dying with nothing. That avoids probate. If you absolutely own nothing except the shirt on your back, there will be no probate.
Then I guess it doesn't matter.
Doesn't
right?
matter. Because probate is getting assets from a deceased person's name, so they're titled assets, onto their beneficiaries. So mason jars buried in the backyard full of cash, that's not going to probate.
Right.
Because someone's going to stand up and put that money in their pocket.
It's gone. Yeah. You can't
gone.
see it. It's like a ghost.
So, but basically dying with nothing. If you have bank accounts, you can designate them at the bank to be payable on death. Payable on death, or POD accounts, that means it's your account until you die, and then it just transfers to whoever you've listed. Named beneficiaries on life insurance policies, that's going to go out, transfer outside of probate. Transfer on death for brokerage accounts, all of those. If you have a named beneficiary, that's going to transfer outside of probate. So those are good things to know. Those are very simple things that if you take the time to do it, it's done, and then nobody has to worry about probate. I mean, I love probate, but most people don't.
Right. I mean, you do it all day long. You know, people love certain things, but at some point, somebody's going, I'm not loving this so much.
Well, and I'll be honest. I mean, people that actually make appointments with me, take the time to sit down with me to find out how they can avoid it, I'm going to give them the straight up answer, because a lot of times people can avoid probate. Joint owners on property. Any joint owner, if it's, tenants by the entirety or joint owner with right of survivorship.
So I know what that means in real estate, but explain that from a title perspective.
Well, that's essentially more than one person on the title, on a deed to property. Joint owners with right of survivorship means as soon as the first person dies, it seamlessly goes to the surviving person.
And it's not always a husband and wife that own property together.
No, it could be business partners, siblings after a probate, because after a probate, a lot of times, 2 or 3 or 5 siblings will own a jointly held property that was, from their parents and whatnot. So things like that will seamlessly transfer to the recipient or the beneficiary without probate. So the other thing that people like to do are, I'm going to say ladybird deeds or life estate deeds on property. You can do that, but there's kind of a tricky way of doing it. You just don't want to add your son or daughter to the deed on your property, because
I haven't even heard of that. So ladybird deed?
Ladybird
deed. Where
deed.
you're just saying, I'm adding somebody.
Well, you're adding them as a remainder interest. You're going to reserve a life estate for yourself. You're going to add them as a remainder, or 1 or 2 or 5 or however many children you want to. And then once that's recorded, upon the person's death, their life estate ends, and then it transfers outside of probate to the beneficiaries. The ladybird deed it's an enhanced life estate deed. So which means when you add somebody to your deed, it's not always a good thing, because one, you've caused a taxable event. So once you do that, say you've owned the property for 30 years and you enjoy that homestead protection of the 3% tax cap per year, you don't want to add somebody, later on, because that would...
It's a change in interest.
It's a change in interest.
I mean,
and
we
now
see
it'll
that
reassess the taxes. You don't want to do that.
The portability exemption, which is what you're talking about, like someone that's lived in the same house for 30 years, they may have a tax bill of like $800 or $900, but then they go to transfer. When the house sells and it goes to somebody else, you may have a tax bill that's going to go to $3,000 after you're done. And so that's what you mean by a changeable event. It's you're changing your interest of ownership, which can spark that exemption. You can get rid of it.
And I'll guarantee a lot of those times it would have been cheaper to allow it to go through probate. So you don't want to do that. But even worse than that, if, let's say dad has passed and mom's alive and she adds the 2 kids onto the deed. Well, if she changes her mind later, the kids are on that.
Yes,
so
they own it.
They own it. So if she goes to sell it, she needs their permission to sell it. And now they're like 1/3 owners. And so they're entitled to 1/3 of whatever comes out of that, which is not a good idea.
I think sometimes people don't think about that. They don't realize, like, once you put their name into the deed as an interested party, they have to actually sell it to you or deed it to you or, transfer that interest back.
Right. And everybody thinks it's, I'll go to Staples and get a quit claim deed and add my daughter or son to it. Because they got this advice from the cocktail party attorney.
Yeah.
The one that didn't go to law school, he's actually a plumber or teacher or something, but it worked for them, so they're going to do that quick fix. And it usually it turns out badly.
And those actually, many, many times, I can tell you from a real estate perspective, we see what they call clouds on title, which means if you go to sell, you're actually going to stop that whole process. And many times you have to hire an attorney to unwind that. So we have to take a real quick break at the bottom of the hour. We'll be back in just a second with Linda Faingold here on Tampa Home Talk, Tampa Bay Elder Law. Back in a minute.
You can't stand to think, and it's already started without you, so find your desperation.
Ask me about an inside secret to save several hundreds of dollars on your annual homeowner's insurance premium. Text the word WIND, W-I-N-D, to 813-377-2775. Again, 813-377-2775.
You've heard this before. Interest rates are at all-time record lows. But if your interest rate is 4% or above, you owe it to yourself to call Silverton Mortgage Specialist. Silverton is a direct lender, and the best part about this is that the entire loan process is handled in-house. From application to close, we do it all in the same building, which means that our loans close fast and our clients know what's going on every step of the way. Our contact info is located on TampaHometalk.com under Radio Show. What makes Silverton different? Products. We offer VA, FHA, USDA, and conventional loans pricing. Best rates with the lowest closing costs. Process everything in-house. It's handled right here and not outsourced to anyone that no one can reach. This way we can avoid surprises. Our people are simply the best, and we know you'll agree. What will closing Silverton Mortgage Specialist mean to you? A smooth process, real home loan value, and personal attention from real professionals. Silverton Mortgage Specialists are here to serve you. Visit TampaHometalk.com under Radio Show for all of our contact details. NMLS 109600 is an equal housing lender and Florida and Georgia residential mortgage licensee.
Hi, this is Aaron Davis, owner of Hillsborough Title. Hillsborough Title is a local, family-owned title agency here in Tampa Bay. Our service, strength, and knowledge make us different. We've served Tampa Bay area for over 30 years. From Polk County to the Gulf, Pasco to Manatee, Tampa Bay, we've got you covered. Call us at 813-712-8888 or visit us on the web at thebesttitle.com. That's thebesttitle.com.
You're buying a house. Congratulations. So while you're worrying about the paperwork, leave the moving part to us. We're Woody & Sons Moving Company, a Florida licensed and insured mover, and we offer same-day written estimates. Plus, no sneaky mileage, stairs, or additional stop fees. All we ask is that you check out our great ratings on Google and Angie's List, then go to woodyandsons.com to learn more. Whether you need a full-service pack and move or some extra hands, at Woody & Sons Moving Company, we move you.
Hey, this is Hal Elrod, author of The Miracle Morning, and you're listening to Tampa Home Talk.
Good afternoon. Welcome back. You're listening to Tampa Home Talk, and in studio today we have Linda Faingold with Tampa Bay Elder Law, and we are talking all about, what probate is, how to avoid it, how it happens, what goes into it, and we got some other really cool things that we're going to talk about, and they're things that a lot of people don't think about, but they're very important in today's world because you never know what tomorrow's going to bring. Our studio call-in lines are 727-441-3000. Again, 727-441-3000. So one of the things I know we talked about before and during the break was guardianship for your kids. Like anybody listening that's a mom like me, they're probably thinking, well, I might not need that, or I don't have a lot of assets. But if you have kids, that might be a big deal to you.
It's a huge deal because naming a guardian for your kids, if you're unable to raise them yourself, who is going to raise my child for me? So that's why every single new parent needs to go at least get a last will and testament to name guardian for their child. We all know that no one's going to raise our kids as well as we can ourselves. However, you got to pick somebody, because what you don't want is people from the family that think that there's money coming with that kid from Social Security or whatever.
Which sometimes there are.
Yeah,
and you
or there's
see
money
that
from assets, from life insurance policies. And so they come out of the woodwork, the same people, and they want to raise your kids. And
so you'll have your brother Joe that's deadbeat Joe, and deadbeat Joe hasn't seen the kids in 10 years.
And he doesn't
since they
like
were born.
kids.
Yeah. Yeah, he might even like kids.
Exactly. You don't want them, or even, mother-in-law or father-in-law or, anybody else. You know who you don't want. So that's how we start doing the elimination process. We may not know the perfect person, but by eliminating the people in your family that you don't want raising your kids, and you might find that it's not somebody in your family at all that you'd rather.
I was just thinking that.
Yeah.
I was just thinking there's people that I've known that they're like, I wouldn't pick anybody in my family to raise my kids.
Right.
And so in that time, it might be like a godparent, right? A really good family friend.
Exactly. And again, the most important thing is to get that in writing. And in doing a last will and testament, when you have minor children, you need to name that guardianship clause. Because as a parent, that's the most important thing. All the rest of the stuff, dividing your assets after your death.
It's just stuff.
It's stuff. It's important. I mean, we all work for our stuff, and we want it to go to who we want it to go to. But who's raising my child? That's more important than anything.
Absolutely. I would totally agree. The crazy thing is there's all these things, and, again, it's one of those subjects that nobody wants to talk about,
right?
But I guess the bigger question is, how do you prepare for your intentions? That's
sit down with an estate planning attorney. Most of us do free consults. I can't speak for everybody, but most do free consults, tell you what your options are, and then you go home, think about it. Because some, like picking the guardian for your children, that's going to take some planning. That's going to take some thinking. That might be a difference between the husband and the wife and what they agree upon.
And if you don't have that, and you don't pick who the guardian's going to be, and let's say it's a husband and wife, and both parents die in a car accident, then the courts are going to decide.
The courts will decide. And again, it's going to be somebody within the family or whatever petitioning for guardianship of those children.
Hopefully. I mean, not always.
And unfortunately, sometimes the person that wins is the one that can afford to keep the dog in the fight the longest. And that's not always the person that you want.
This should be the best person to raise the kids.
Exactly.
Yeah.
So again, putting it in writing is the most important thing.
Absolutely. It's like, it's one of those things that, again, nobody wants to talk about, but we should, because especially if you have kids, they're number one.
Right.
So, and we talked about this as well. Why would someone at 19 years old need a will?
Because they could get wiped out on Route 19 over here and, hit by a truck from a major company. And so now the estate is going to sue this company for a wrongful death suit. And
so let's say, like, to use as an example, you have big box beer truck, right? And they hit your 19-year-old child.
On a motorcycle, let's say. And child passes away, and now child's estate is worth $1 million. And who's going to get that $1 million, right? Sometimes I've actually had a case where that was the scenario right there. And this person wasn't married, didn't have any children. So as I told you earlier, by statute, it's going to look up the bloodline to the parents. This child's parent, or the dad, was not a part of this child's life ever. He didn't even know him. But that dad, the deadbeat dad, let's call him, was entitled to 50% of that estate. And if that child of 19, because after 18 you want it in writing, that child of 19 had it in writing, he could have left the whole thing to his mom or his sister or his girlfriend or whoever he wanted to.
So here you have this mom that probably worked 2 or 3 jobs.
That's exactly
to
the
raise
case.
her kids.
That was exactly the
deadbeat
case.
dad Joe is not around, and now deadbeat dad Joe all of a sudden realizes, might not even went to the funeral, or whatever.
No.
But here he realizes all of a sudden that his 19-year-old son or daughter is worth money,
right?
And he's all of a sudden super dad.
Well, he's not super dad. He just can actually sit back and wait for it to pay out.
Well, he's playing the super dad role, right? I mean, like,
no, actually, in this case, unfortunately, he was a drug addict dad, and he just waited until the money came, and it was over $1 million. So he stood to
and that's so
claim
sad.
$500,000. Yeah,
it's so sad because you think definitely it all should have went to the mom, but even if charity got the other 50%, it's better than some parent that's going to do drug and OD. It's just like.
Yeah, it happens. That's, again, the biggest thing about estate planning is getting your wishes and your thoughts in writing. And it's my job as the attorney to get it down in writing in the proper legal form, of course. And that's, it's pretty basic. And it shouldn't take very long. And it's usually not that expensive to sit down and have that done. Once it's done, it's not one of those things you take out your papers at Christmas or Thanksgiving and pass them around the table. Once it's done, you pack it away and it's there. It's kind of like an insurance policy. You might never need it, or you might not need it for years and years and years, but it's done.
The other thing, too, that's an important point, and feel free to touch on this, if I'm not mistaken, you usually need that original, correct?
Yeah. Definitely for a last will and testament, you need the original, because that's what's going to get filed with the court.
And a copy, they're saying, is not as good as the original, right? Or
No.
People can fight that?
The copy's not as good as the original. There are times when the original absolutely cannot be found, and then we have to petition the court for what they call best copy. And then somebody has to prove that was actually not revoked. Because to revoke a will, all you have to do is either cross through it, rip it in half. So that's why if the original was actually intentionally revoked and the copies were still out there, that's where we get into some issues.
Which can happen. You have rotten kids that do things, or I see it even in where
I see
I'm
all the
at.
rotten kids.
Yeah, I don't even deal with the stuff you see, but I see that. I've had clients that have come to me and said, I bought this house, I paid cash for it, and I don't want my kids to have it.
Yeah. Yeah.
And they might have someone that's a caregiver that's not even one of their children.
I know, but you know what? As an attorney, we have to be careful of that, because I see that a lot of times too. A caregiver that works for an agency all of a sudden is inheriting the house, and you're like, how did that happen? Or the caregiver child, even one of the 3 children or one of the 5 children is actually the caregiver. Sometimes it's legitimate. You know, they're the only ones that help mom or dad out. They're the ones that take them to the doctor. They're the ones that do everything for them. If you make it to the attorney to make changes like that, we have to make sure that they're not being influenced or coerced.
I had my grandfather, he just passed not too long ago, and his cousin was like one of the only remaining, siblings of that age that was around, and she was in Vegas. And, they didn't really talk a whole lot. They were distant cousins, but they're really close growing up. And she knew that my grandfather was one of the only family members she had left. Her husband had passed. Her daughter had actually a stroke, and she passed. And, we got these random calls out of the blue saying, I need help. Like, stuff's going on. We're like, what's going on? What's the matter? So, my family and I took a trip out to Vegas, of all places, right? All the Shadesters live out there. And the state of Nevada is so, like, if you read all this stuff, it's crazy. The stuff you'll read about the Guardian, like all this stuff. Well, her estate was worth several $1 million. And we didn't know. We were just going out there to help her anyway. But what happened was she ended up calling, and then one of the housekeepers, like the guy that had managed her estate and financial advisor, he actually had her redo the will to him.
Yeah.
And
it's kind of improper, wouldn't you say?
Yeah. The housekeepers and the people that were caring for her and taking her to the doctor, they got really close with her. Yeah. And they found out, they got wind of it. And she actually called my grandfather and let him know. And then when we found this out, this guy's wheeling my aunt all around Vegas to take her to look at nursing homes when she's got plenty of money. She should never have to live in a nursing home.
Right.
And unfortunately, I hope that our court system is not like this, but I know out there it's very corrupt. Like, you can't even, us being a Florida resident and then you can't even be a Nevada resident. They have grandfather periods, and it's so it's awful. Like, you read it, can't even believe it. And guardians usually are not assigned unless there's no money, right?
Right. Well, no, guardians are assigned with people with money.
Yeah.
Absolutely.
So, I don't know. That happened there, and it was crazy to see that. It opened my eyes to a whole other side of things that, you don't even think people like that exist.
Yeah, no, unfortunately they do. And when people don't have immediate family, that's when they become, preyed upon. And you see it all the time. It's either the caregiver, but what's really improper and it will never happen, or should never happen, is the financial planner that you're talking about, or the attorney. They should never get part of that estate unless they're actually a direct relative, obviously. Right. But if you ever see that, that is,
SEC complaints in different states, you name it, it was there. So for the person that is listening to this and maybe they already have their paperwork, where's the best place to leave the original copies of any and all of those documents?
I always say a safety deposit box at the bank and then let your personal representative or successor trustee know where it is. You certainly don't have to show it to them, but let them know where it is, what bank. Some people don't have safe deposit box anymore, and fireproof box at home. I don't like that, but it's second best. Or off-site, especially people that live in nursing homes and things like that. In my office, we keep a lot of originals for some of my clients in that very instance where they live in a nursing home or assisted living and they don't know who's going to come, or even one of their children. Because again, if there's an uneven distribution and Debbie Joey's going to tear up that will because he wants at the very least an even distribution with
so he can probate it.
Exactly. So.
It's I've heard of it staying actually with the attorneys as well. Yeah. So that's why I don't know. And how would you even know what's in a safety deposit box, right? If no one's ever shared, they don't have it. Right. Then what?
Well, and a lot of times my clients will come back to me and tell me where they keep it. We put it in their notes and it's secure. And then after one's passing, a lot of times we're notified and then we identify where it is.
Well, you're listening to Tampa Home Talk. Excellent conversation today around probate, elder law, planning, and all of the such. We're going to take our last break of the day. We'll be back in just a minute, and when we come back, we'll hop into a few more of those things. We'll share some stories and hopefully answer a few more questions that you might have sitting back listening. Back in a minute.
You've heard this before. Interest rates are at all-time record lows. But if your interest rate is 4% or above, you owe it to yourself to call Silverton Mortgage Specialist. Silverton is a direct lender, and the best part about this is that the entire loan process is handled in-house. From application to close, we do it all in the same building, which means that our loans close fast and our clients know what's going on every step of the way. Our contact info is located on TampaHometalk.com under Radio Show. What makes Silverton different? Products. We offer VA, FHA, USDA, and conventional loans pricing. Best rates with the lowest closing cost. Process everything in-house. It's handled right here and not outsourced to anyone that no one can reach. This way we can avoid surprises. Our people are simply the best, and we know you'll agree. What will closing Silverton Mortgage Specialist mean to you? A smooth process, real home loan value, and personal attention from real professionals. Silverton Mortgage Specialists are here to serve you. Visit TampaHometalk.com under Radio Show for all of our contact details. NMLS 109600 is an equal housing lender and Florida and Georgia residential mortgage licensee.
Hey, Katrina Madewell here. Just wanted to make sure you know how to reach us on our off-air number. If you'd like to connect with myself or any of our guests, you can call us at 813-377-2775. Again, this is Katrina Madewell, host of Tampa Home Talk, and to connect with myself or any guests we have on air, just call or text at 813-377-2775. 813-377-2775.
You're buying a house. Congratulations. So while you're worrying about the paperwork, leave the moving part to us. We're Woody & Sons Moving Company, a Florida licensed and insured mover, and we offer same-day written estimates. Plus, no sneaky mileage, stairs, or additional stop fees. All we ask is that you check out our great ratings on Google and Angie's List, then go to woodyandsons.com to learn more. Whether you need a full-service pack and move or some extra hands, at Woody & Sons Moving Company, we move you.
Welcome back. You're listening to Tampa Home Talk. Thanks so much for joining us today. If you missed any part of our show today, it's completely relevant to everyone. And we talked about some of the importance of planning, and preparing for your intentions, no matter what they are, especially if you have kids. So if you missed any part of the show, hit us up at TampaHometalk.com. We'll post them all under there under the radio tab. You can catch us on any podcast player, and we're also on Facebook, Twitter, and across the web. Just look for Tampa Home Talk, and we'll post Linda Faingold's information with Tampa Bay Elder Law, so you can also reach out to her off air if you have any questions that we didn't cover on the show. And I know you were saying a big chunk of what you do are revocable living trusts. Right. So explain to the person listening and me, what's a revocable living trust?
Well, that was actually the biggest vehicle, I guess, that we use most of the time to avoid probate. A revocable living trust is creating a trust, putting your assets into the trust during your lifetime. If you think about it as like kind of creating a company, so a separate entity, you're retitling your assets into that company or that trust during your lifetime. You're the manager of that trust during your lifetime, but upon your death, your successor trustee, or think of the vice president of that company, taking over.
Which is somebody you're assigning.
You're assigning, you're selecting. There's no court involvement because that successor trustee can immediately liquidate. They still have the same duties. They still have to satisfy all of your valid claims, creditor claims, and things like that. But there's a lot of things you could do with a revocable trust, especially if you have minor children.
Now, is that one person, two, like husband and wife?
A husband and wife will have a joint trust. A single person would have a single trust. But a lot of people do trust when they have minor children because you can stretch out a distribution to that minor child. That's exactly why I have it.
Fantastic point.
Yeah, I have an 11-year-old. Now, I'd like to think she's going to grow up to be a productive member of society, but I have no idea. So by the time, if I pass away before she turns 18 with my life insurance and my assets, it's going to be a lot of money. If you don't have a trust and you just have a will, that child is going to get a lump sum of money at the age of 18. And I guarantee by the time she's 19, it'll be gone. So
we can't, right now, my kids and I are reading Smart Money, Smart Kids by Dave Ramsey.
Yeah, big
and
Dave
I'm trying to get them, me too, I'm an ELP, but I'm trying to get them to understand these things and put the pieces of the puzzle together. Who do we know like this? Mm-hmm. And I can't stress to them enough that, sometimes people, and Dave Ramsey talks about this a lot, right? The dummy that inherits money and they just blow through it. They think, if I can get the words correct, one of the things they were saying was, money is finite. There's not an infinite supply of it. Right. So, and people that have not consciously built wealth, they don't understand that.
Well, right, especially, if you
Hence
haven't
the
earned it
18-year-old.
yourself, it's easy to blow. I actually had a case about 3 years ago. 19-year-old inherited a lot of money. The first payout was $200,000, but it was in a probate. But we liquidated $200,000. We gave a partial distribution, and 8 months later, he was out. 8 months later, he blew through $200,000.
Like, what did he buy? Did he even have a house or
Well,
anything to show for it?
No, he came to Florida. He came from a different state. Came to Florida, bought a Hummer. Okay, so that's important. Bought a Hummer, and then after a couple of weeks, he decided he didn't want it. So he traded it in on a new Corvette, or maybe it was vice versa.
Something.
Yeah. So he went back up north with the Hummer. So he had a Corvette first. He went back up north with the Hummer. He didn't have a garage that would fit that Hummer, so he built a garage. Right? Really
Silly stuff.
logical stuff. Anyway, but that's what happens. When you don't earn it yourself, it's easy to blow through. And especially children that have, at that point, no parent supervision, no parent
they
guidance.
might have $500 in the bank, and then they inherit $500,000 or $1 million, and they think, oh, this is an infinite supply. It's going to go on forever. This is a lot of money, $1 million.
Yeah, but the only thing is, it's the ones that don't inherit quite as much. Maybe they've inherited $50,000, and you get these young kids, 18, 19, 20-year-old kids that think, I got $50,000. I don't have to go to college. I could go live on the beach.
Yeah.
$50,000 will be going in a
nothing.
few weeks.
And I hate to see that, when I have people, and I have a couple right now that's like in the process of a divorce and they're netting a pretty good amount. And I'm like, please put X amount into a CD so that when you don't want to rent a year from now, you've got your down payment in a CD. Even though it's not paying a lot of money, it's out of sight, out of mind,
Right.
Put it into something that is going to make you money, give you a place to live. Even if you buy a little condo and you have a couple $100 a month maintenance fee, have something at least to show for it if you're going to blow through it.
Right.
So what about as you accumulate assets? Do you have to update that or change it or move it?
No. You reassign your assets into the trust. So my bank accounts would say the Linda Faingold Trust. My brokerage accounts would be in the Linda Faingold Trust. So that whatever amount of money is in there can go up or down. Upon my death, whatever the amount is will pass through my trust.
So you create the revocable trust. You assign who's going to manage that if it's not your spouse or it's somebody else, a child, a sibling, or whatever. And then essentially, whenever you buy or obtain a new asset, like another property or
Right, you're going to
a
buy it
401k.
in the name of the trust.
Okay.
Right. And then with that, as we were starting to talk about before, you can stretch out that distribution. So it could be for a minor child or minor children. My daughter's not going to get hers until she's 40. I mean, it's going to be 25, 30, 35, 40. And
Which
I
that
can
makes
change
sense.
that. I
Yeah.
can change that. As if she gets to be 26, 27, she's gone to college or has a good job, I can change that. No problem. She can have it outright at that time. But at 11?
Yeah,
I have no idea what she's going to do.
When you're the age our kids are, I mean, you have good intentions and you can only plan so much to set them up for success, but then they become their own people and they're going to do what they want to do.
Exactly.
And the last thing I want to do is, have that kind of money sitting around after life insurance policies and all that stuff to a child that's going to, buy a Hummer where it doesn't fit in the garage.
Exactly.
I mean, you think about what it takes to consciously save, 15 to 20% of your income. It's a lot. There's a lot of things we'd like to buy with that money.
Mm-hmm. And they don't have the concept of what it took to earn it. So it's just money burning a hole in their pocket.
So what about like in the cases where we see, for example, in the scenario you just said, when you buy something else, you buy it in the revocable living trust. So like if someone's buying an investment property, a lot of the lenders are not going to want you to buy it in the name of a trust. Like that's a big issue, right, with lenders and banks. Yeah. So how do you get around that part of it?
You can execute a deed after the sale is complete, and then to put it in the trust from you as individual to you as trustee of your trust.
Which is quirky. You have to be careful with that kind of stuff too, because all the loans have what they call due on sale clause, which means if you're in default, they can call the whole thing due.
Right. And you don't want to mess with the loan, obviously, so you want to make sure that keeps getting paid.
Yes, definitely. Most of the time, if that old saying, if you pay, you stay, you don't, you won't.
Exactly.
As long as you keep the mortgage on time, everything's going to be good.
Yep.
Have you seen any issues where lenders have called notes due or anything when someone's passed?
No, because here, I usually tell, if the child has inherited it, let's say they've even moved into that house, it doesn't send any red flags up if that is still being paid. So, we can change the title through probate and they still pay the mortgage. The mortgage is getting paid. The lender is not going to, there's no red flags at that point.
Right.
So have them paid off. But a lot of times a lot of times in probate, people have their own houses already, so it gets sold. The mortgage is satisfied at that time, and then
Right.
it's the equity of the house that gets split. To the
Right, because a
beneficiaries.
lot of times they don't want to take on their parents' house. I mean, especially a lot of people of different generations, like the boomer generation, there's a big black and white between how they are. Some of them have so much stuff. You walk in, it's like a hoarder's house, and the kids don't want to inherit that, because then they have to go through all that stuff.
Well, they got to go through that anyway, or unless you have a company that comes in and does it. But
Right.
generally, the personal representative and all the other beneficiaries are going to go through, take out the things that are worth value, and then have some kind of an estate sale or donate, and then
Which is hard, I mean, I've had families where they're selling the property. I just had one where the brother was here from New York selling the property for his sister. And, I'm just like, I go there and I'm like, it's probably one of the hardest things you ever had to do. And he's like, you have no idea, Katrina. I said, no, I really don't. You're right.
yeah, especially if it's your parent.
Yes.
Or in one of the cases I have right now, it's the 80-year-old parents that are doing it with their son's estate.
child.
He had passed. He was 53, and they're going through, and it's just heartbreaking. And just to have to actually pick up his things and put them back down, or
Yes.
sell them, or donate them, and it's terrible.
It takes a long time because there's a lot of emotions involved in that.
There's a lot of emotions. Yeah.
So some of the other things you do are veteran benefits and Medicaid.
Yep. Medicaid planning is definitely for people that are going into nursing home. We like to get them qualified for Medicaid, so Medicaid pays the exorbitant fees of nursing home costs. And then veterans benefits, anybody that's needing extra help at home, if your spouse was a veteran or you're a veteran yourself, there's what they call aid in attendance that they're entitled to receive. And it could help defray the costs of at-home care or assisted living.
And so most of the time, I like to think the Veteran Administration does a lot of good things for their veterans, but I think there's times when they should pay and they're not, right? And
Well, you know what the thing is? I have a lot of veterans that don't know anything about this benefit.
Right.
I had a veteran that came in. He retired after 35 years, and I told him about it. He wasn't at that point yet, but I said, hey, if this ever comes about, just know the benefit is out there for you. And he just looked at me cross-eyed. He had no idea. And then actually, for the veteran, it's up to $1,800 a month that they could get for that assisted living or that at-home care coming in.
I was going to ask you if they have that, if it's an option to do in-home care.
Yeah, it's aid in attendance, so it's just to help defray those costs, and it's up to that amount. So, if they only need $600 a month, then that might be all that they're approved for. But they had to get online and apply for the benefit. But like I said, most veterans don't even know about it.
No,
and it's huge. Sometimes it's the difference between someone being able to live at home versus having to live with maybe their children or things like that. So.
It's so surprising because we see it even on our end, Linda, where, if you were through the military and you have honorable discharge, you can qualify for your VA loan. You really can buy with zero down, like $500, your escrow deposit, get you in a home. It's way better than renting, especially with the rates where they are now. And I just hate to see anyone serve the country and not take advantage of that benefit.
Exactly. But they need to know about that benefit.
Exactly. But so many people don't. So you're listening to Tampa Home Talk. If you missed any part of the show today, you can catch it online at tampahometalk.com under radio. We're also on Facebook and Twitter. Just look for Tampa Home Talk. It's been my pleasure to have you in studio today, Linda.
Thank you so much.
Linda Faingold with Tampa Bay Elder Law, talking all about probate, estate planning, and things you can do to leave your legacy exactly the way you want it.
Exactly.
Thanks for joining us today. We'll be back here same time, same place next week. If you missed us, catch it online, tampahometalk.com. For this week, we're out.
'Cause it's a